So welcome everyone to this webinar, International Data Transfers, Navigating the UK Regime. This webinar is being hosted by the law firm VWV, where I work, in association with EMIG. My name is Paul Gershlich. I'm a partner at the law firm VWV, and I am head of our pharma and life sciences sector. We've been members of EMIG for 12 years. I'm chairing today's webinar. I'm co-chair of the EMIG Compliance Special Interest Group. Just some housekeeping points which you may have seen already, but if not, let me just tell you, first of all, this session is being recorded. If you have any questions to ask, you have the choice. You can either submit the questions anonymously, or if you don't mind your name being mentioned, then please do put your name. It's always good to know who we're talking to keep it as live and fun as possible. There is a chat box at the bottom. You can put in chat for the VWV hosts, but that most of all, if you're asking any questions, that should be on the Q&A box. So please put your questions for the panel in the Q&A and not chat. Chat is for any technical issues. So I mentioned that we are running this for EMIG. There are lots of people today here who have come via EMIG, who are members of EMIG. I know that there are also quite a few people who have come through the VWV mailing, people who are on the VWV mailing list. I should just say, if anyone would like to receive the VWV Pharma and Life Sciences updates and event invites, then please do let me know. You'll be able to contact me on the chat. But anyway, wherever you've come from today, welcome. We hope you enjoyed today's session. Data protection is a very hot topic in the Compliance Special Interest Group. It's very popular. 6 months ago, we had a general update on data protection by Vicki, who is a partner in the data protection team at VWV, and Bronwen Jones, an associate. And both of those, Vicki and Bronwen, have come back today to give you a deeper dive into one of the issues that came up then and that there was a lot of interest in hearing more about. And that is about international data sharing, and particularly navigating the UK regime. So without further ado, I'd like to hand over to Vicki, who will be speaking first. Thank you. Vicki.
Thanks very much, Paul. Oh, well, I've lost my, there we go. Sorry, my computer's very sensitive, so it does tend to skip slides slightly quickly. So today, as Paul said, we're going to talk about international data transfers. We'll start off with talking about what is an international data transfer, or an international transfer of personal data, because that's really quite key to whether or not you need to then look at this regime in more detail. We'll then look at the rules on international transfers. So if you are making an international transfer, what the UK GDPR calls a restricted transfer, what actually do the rules say? Because it's not just about standard contractual clauses. However, the most common safeguard for international transfers are standard contractual clauses, and now the International Data Transfer Agreement, which is the UK version, essentially known as the IDTA. So Bronwen is going to talk you through those regimes and when they apply, and how you use those documents. And then I will talk very briefly on the future of UK adequacy, and you'll understand why that's important, hopefully, as we're going through today. So without further ado, what is an international transfer? Now, I've called it an international transfer because that's how I understand it in sort of normal language. The UK GDPR refers to it as a restricted transfer, and that's because there is a restriction on making these transfers. But until you know what restriction, until you know what what to do about that, you need to understand, am I actually making a restricted transfer or an international transfer? So essentially, this means now that we are no longer part of the EU, any transfer of personal data that you make to outside of the UK is likely to be an international transfer. And there are a couple of questions that you need to ask yourself before you make this decision. And the first one is, does the UK GDPR actually apply to this transfer? Now, for organisations that are based in the UK, it's obviously the answer to that is yes, because the UK GDPR applies to what you're doing because you have a base in the UK. It doesn't matter whether the data subjects are based in the UK or whether the data subjects are based abroad. If you have your physical presence in the UK GDPR applies. However, and also if you're based in the UK, but your actual processing of the personal data takes place outside of the UK, perhaps you've instructed a data processor who operates in another country, because you are the controller, that is still an international transfer. You are still governed by UK GDPR. The data processor, just in case anyone on the call isn't aware of that term, is a third party that you instruct to carry out some sort of operations or processing of personal data on your behalf. They have no right to use the information for themselves. A classic example of this is a payroll provider. So if you use, you might use a payroll provider that's based in somewhere like Australia, and you will send them your data. They will do your payroll processing for you and pay your staff. They can't actually do anything else other than process payroll for you. That's all they can do, so they are a data processor. But even though they're based in Australia, because you are based in the UK, you are the controller, you are the person who's legally responsible, so you are subject to the UK GDPR when that process is being carried out. If you're based outside of the UK, but you offer goods or services, regardless of whether they are paid for, or you are monitoring behaviour of individuals in the UK, you are also subject to UK GDPR. So if you are an organisation that doesn't have a physical base in the UK, but you are offering goods or services or monitoring behaviour of individuals based in the UK, you may also be subject to UK GDPR. So then if you make a transfer to any country outside of the UK, so you may be based in, I'm going to use Australia because they're not subject to an adequacy decision, as you'll learn later. So let's say your physical headquarters is in Australia, but you were running a trial that's using participants based purely in the UK, because that's the pool of people that you want to use. So you'll be processing the personal data of data subjects from the UK. And it's likely that that processing would be covered by the UK GDPR, depending on whether it comes into the definition of offering services to individuals in the UK, or it might be classed as monitoring the behaviour of participants, depending on the type of trial, what it's actually doing, and how that is structured. And again, all of that, we could do another webinar just on the extraterritorial jurisdiction of the UK GDPR. But that's your first question. Is this a transfer that is covered by UK GDPR? So if it is, so if you're covered by UK GDPR, then you need to go to step 2, which is, are you initiating or agreeing to send or make available or accessible information to a receiver outside of the UK? And that third sort of bullet point is the flip side of that. So you're not making a transfer if you're not doing that. So what does that mean? If you are initiating or agreeing to the personal data being transferred, that would likely mean that you are entering into an agreement with a third party based outside of the UK. So if we go back to the Australian payroll provider example that I gave just now, you are based in the UK, your payroll provider, your processor is based in Australia, you are agreeing to and initiating the transfer of that data to Australia. So that would be a restricted transfer or an international transfer. If, however, you outsource all of your HR services to another organisation based in the UK, so a UK HR consultancy company, and your agreement is with them, and that UK consultancy company uses an Australian payroll provider, and that's part of the service that you are providing. In that circumstance, you would not be initiating the transfer of personal data, even if your HR consultancy asks you to send the data directly to Australia, because the initiation and agreement is between the HR consultancy and the Australian payroll provider. So in that situation, they could be a sub-processor, for example. You are not responsible for the international transfer, so you don't have to enter into or worry about any of the restrictions, because you are not, in that scenario, making an international transfer. So you're making the international transfer if you are initiating or agreeing to it. You are not making an international transfer if you have an agreement in place with another UK organisation and they are using a processor or a sub-processor based in another country, and they are then responsible for that part of the transfer. This is one of those situations where you use a simple example and it feels, oh yes, that makes sense and it's common sense, but it is actually a really complicated concept to get your head around. So if you do have any questions, please do pop them in the Q&A box or speak to us afterwards, because again, some of these can be quite difficult to untangle. You have to send or make the information accessible or available. And that means that if information is in transit and it goes through a number of different countries, but actually when it's in those different countries, it's not accessible and it's not being manipulated, that doesn't count as an international transfer. I don't understand computers enough to understand an example of when that might happen. But my understanding is if it doesn't stop, so it might be routed through servers based in Australia, but if it then comes back to the UK, there's been no international transfer as long as it doesn't stop long enough in Australia for it to be accessible and or manipulated in some way. Those are examples of international transfers. It's also important to bear in mind that if you are all part of the same legal entity, it's just that there is a physical base in another country, that's not an international transfer, because the legal entity, if you have a base in the UK, will be subject to the UK GDPR, and so will your office in, let's say, Australia again. If you have an office in Australia, but it's one legal entity based in the UK, then that would not be an international transfer. It's also not an international transfer if your employee is accessing information from another location. So let's say your employee is on holiday in Spain, and for whatever reason they decide to do some work, they open their laptop, they log into your system and they're working on whatever it is they're working on. That's not an international transfer, so you don't actually have to worry about the transfer rules in that situation, which is really helpful guidance actually, because especially now when everybody is much more used to working from home and not working from an office, it does mean that employees can be based elsewhere without worrying about personal data. There's still the requirements to put in place security and making sure that the personal data is safe when it's in transit, etc. You don't have to have the additional concern about international transfers in that situation, which is helpful. So that's what is an international transfer. So if you look at what you're doing and you decide I am making an international or a restricted transfer, what does the UK GDPR actually say? Because quite often clients will talk to me about making international transfers, and then they'll immediately start talking to me about the IDTA or standard contractual clauses. And actually it's worth taking a step back and working through what the UK GDPR actually says. So what it says is Article 44 of the UK GDPR says you cannot make an international transfer without putting in place a safeguard. And there are a number of safeguards in place that might be applicable to the transfer before you jump straight to standard contractual clauses. And the most commonly used are where there is an adequacy decision, which I'll talk about all of these in a bit more detail in a second. Or you use a or you use a safeguard that's set out in Article 46 of the UK GDPR, and the most common of those are binding corporate rules, the contractual clauses, which we keep mentioning, or a derogation from the requirement to have a safeguard in place. So what is an adequacy decision? Essentially, it's a decision of the UK that a particular country has laws in place which protect personal data to the same level that the UK GDPR does. When the EU GDPR came in back in 2018, the idea was that it was the best level of protection that was available in the world. So this was the sort of gold standard. And therefore, if other countries had laws that came close enough to that standard, then that was okay. The data is not at risk if you transfer it. Since we left the EU, we get to make our own adequacy decisions, which may be helpful. We're yet to see very many being made, but it could be so it's possible that there will be a wider number of countries. But for the moment, it does include all countries based in the European Economic Area. So that's the EU countries plus the extra ones that I can never remember. It includes Gibraltar, the Republic of Korea, and also the ones listed there: Andorra, Argentina, Switzerland, Uruguay, etc. And then there's also Japan and Canada, but it's only specific information. So in Japan, it's only if you are transferring private sector information to a private sector organisation. In Canada, it's information that's covered by their equivalent of data protection law, which only applies to essentially commercial organisations. But if you are transferring information to Canada, then you need to check whether that organisation is subject to their privacy laws. If they are, it's covered by the adequacy decision. If they're not, then you need to put additional transfers, additional safeguards in place. So if you're transferring to any of those countries, that's your safeguard, and you don't have to do anything else. If you're transferring to a country that's not on that list, such as Australia or the United States, you then need to look at Article 46. But before you use any of the safeguards set out in Article 46, you actually have to do a transfer risk assessment. And this is a new requirement that came out of the Schrems decision. And it essentially, after the Schrems case, after Max Schrems brought a case against the standard contractual clauses and the UK-US Privacy Shield, and his argument was these are not enough on their own to protect data. So the requirement now is that you carry out a risk assessment on that data, and then you carry out your safeguard, and then you put in place your safeguard. The idea being that there may be other mitigations that you can put in place before you look at your safeguard. So for example, if you carry out a risk assessment on the data that you hold, that you want to transfer, and you decide, oh, actually, we may be able to encrypt it to a particular level, and that's going to offer additional protection, you would do that in addition to the safeguard that you're going to put in place. There is now some guidance and a template on the ICO website of how they expect you to carry out a transfer risk assessment. This is all still fairly new, and organisations are still getting to grips with it. And again, we could probably talk for a whole day just on transfer risk assessments. But the guidance and the template is there to assist you. And once you go through that, if you've got any further questions, obviously, we're available to assist if that's helpful. So you've done your transfer risk assessment. You then decide which safeguard you're going to use. And there are binding corporate rules. And these are essentially a set of rules for multinational corporations that are approved by the ICO. Now you will need probably UK and EU binding corporate rules, so 2 sets. And the UK guidance, I haven't had to advise on these post-Brexit. So I haven't had to go into the detail of the differences between the UK and the EU. The UK guidance seems to suggest that they're not different enough that it should be problematic. You should be able to, it should be fairly simple to get 2 sets of rules in place that will work with both regimes. But in practice, how simple that is, I'm afraid I don't know, because I've not had to do them. But essentially, if you are a multinational corporate group or a joint venture or a franchise or something like that, you can use these binding corporate rules. It's basically a contractual arrangement between all of the organisations, regardless of where they're based, that say that you will apply the GDPR principles and rules to your processing of personal data. And that, again, protects the personal data, whatever jurisdiction it's in. Certainly pre-Brexit, these could take years to get approval. And as I said, I don't know if the ITA is any quicker because I've not had to advise on them, but you would hope so because they're only dealing with one country set of BCRs now. Far more common are contractual clauses, and these were previously known as the standard contractual clauses, SCCs, and these were produced by the EU. Since Brexit, the UK government has issued their own version, the International Data Transfer Agreement, so the IDTA. And you've actually got 2 options. You can use, there's an IDTA, so a standalone agreement that can be used controller to controller or controller to processor. And they're sort of similar to the old EU standard contractual clauses, but slightly different because they're the UK version. Or you can use the EU standard contractual clauses, but you have to put in an IDTA, what's called the IDTA addendum, so an additional section on the end. But Bronwen is going to go into these in a bit more detail, so I won't go into that any further. So if you can't use standard contractual clauses, or you don't want to use standard contractual clauses and BCRs aren't an option, there are some derogations, but you can only use these if the Article 46 mechanisms, the other ones, are not available. So if you can't use standard contractual clauses for some reason, or you don't have BCRs because you're not a multinational organisation, then you can go to Article 46. And the most common ones that we would use for these are where you've got explicit consent from the individual. So if it's not appropriate to enter into standard contractual clauses because of the type of data or the limited nature of what you're doing, then you can ask for explicit consent from the individual. Consent would have to be the UK GDPR level, so that means it would have to be informed, it would have to be freely given, have to be an unambiguous indication of the data subject's wishes, and here it has to be explicit, so it has to be very clear that this is what the individual is signing up to. If explicit consent can't be used or isn't appropriate, you can then use the derogation where what you are doing is necessary for a contract with the individual or necessary for pre-contractual steps at the request of the individual. So perhaps you need to transfer some personal data to another organisation. Where this has come up previously is where an organisation wanted to do a pre-employment check on an individual that had been working abroad. So they were sending the individual's information to that country so that there was an agency in that country that was doing the pre-employment check for them to then send the information back. So they might have been able to use the derogation if the standard contractual clauses weren't appropriate to put in place between them and the organisation that was carrying it out. I have a feeling in that case they did use actually contractual clauses, but pre-contract requirements would have been an option there. And finally, if you are doing a transfer that is not repetitive, relates to a limited number of individuals, and is necessary for a compelling legitimate interest or compelling legitimate interests, then you can use that derogation. So if it really is a genuine sort of one-off, not to be repeated, not a vast number of individuals type of transfer, and you can't do what it is you're trying to do without this transfer, then this derogation is open to you as a sort of last resort. So I'm now going to hand over to Bronwen, who's going to talk to you in a bit more detail about those contractual clauses, because those tend to be the most common of the safeguards. Thanks.
Great, thank you, Vicky. As Paul said, I'm Bronwen Jones. I'm an associate in the data protection team here at VWV. So I'm just going to talk you through the International Data Transfer Agreement versus the EU standard contractual clauses plus the addendum, which are the two options that you've got there for these types of contractual clause safeguards. I suppose the main question really is, well, which do I choose? And that probably depends on the type of international transfer that you're going to make and the facts of the situation. So if I just talk you through some of the pros and cons of each, and then at the end give kind of a view on when it might be appropriate to use one or the other. So the IDTA then, this is a standalone agreement, and some people consider this to be the more simple approach here because it is just one agreement. It's not particularly flexible in that you need to keep the legals the same, but you do need to then fill in the practical details. So it's in a tabular format. So once you've completed the tables in the IDTA, then that's your document there. The tables cover the practicalities of the situation. So it will be things like the parties' details, the description of the transfer, security requirements as well. And I think what's really good about the IDTA is it allows you to introduce any extra protection clauses that you might require. So once you've done a transfer risk assessment, what you might have identified is that there are additional protections that need to be put in place in order to carry through with the transfer. These might be technical security requirements, or they might be organisational. This can be included in the commercial provisions there as part of the table, and then it can be signed sort of as is, as it were. The IDTA also takes into account that parties might have already entered into what we call a linked commercial agreement. So if you had a master services agreement or something similar, then the advantage of the IDTA is that it allows for this to be incorporated in as the terms of the linked agreement into the IDTA, as long as the rights that are granted under the IDTA aren't weakened in any way or affected by the linked agreement. So just thinking about this from a practical perspective, where it might be quite useful is if you've audit provisions that you've agreed to under your linked agreement, these will also apply to the IDTA. I think the idea of this is to address a difficulty that can be faced when using the new EU SCCs, where their broad audit rights don't really contain process or timing measures, which would usually be included in a linked commercial agreement. So the IDTA sort of neatly addresses that issue there. The IDTA also covers more scenarios than the EU SCCs. So the EU SCCs are done in a modular format, which I will come on to, but they can only be used if it's an importer-exporter relationship, which is consistent with the modules that the EU SCCs provide for. The IDTA can be used in more situations, so it's more broad-ranging. For example, it could be used if you've a processor transferring personal data to an organisation which isn't its instructing controller or its sub-processor. So, for example, if a processor was transferring data to another processor appointed by an instructing controller, you could use the IDTA there, where you wouldn't be able to use the EU SCCs. So as I mentioned, you can add in your additional safeguards, and really the IDTA is trying to here address the need for transfer and risk assessment that was brought about as a result of the European Court of Justice Schrems II decision that Vicky mentioned. This really sort of changed things up because it means that people need to consider not only the risks at the outset of the relationship and the outset of when you think about doing the transfer, but also thinking to protect during the life cycle of the personal data being transferred. And so the IDTA allows for that, in that you can incorporate these additional safeguards, and it's sort of a nod to trying to get you to be able to plug in your supplementary measures into the text of the agreements, although you do need to make drafting amendments to achieve this. So the IDTA includes mandatory provisions. They cannot be amended or removed from the agreement. because if they are removed, then the protections that are offered by the document will be lost. You can remove clauses which don't apply to you. So it's flexible enough that you're not stuck with things in there that are not applicable. But you can't take anything out that is applicable that would then weaken it. So I think a good example of something that could come out is where the agreement is being concluded between a controller and another controller, and you wouldn't need your processing information in there. So that can come out because it's not applicable there. This is true of both agreements, both the EU SCCs and addendum and the IDTA, but it also includes provisions to allow the ICO to make changes to the IDTA, such as to correct errors, or if there were changes in UK data protection laws as well, which incorporates provisions then to allow the parties to end the IDTA if the changes would have a substantial, disproportionate and demonstrable increase in costs or risk under the IDTA, and these can't be mitigated by the parties. So this is true of both documents, but I think it's just worth mentioning, given that we've got the data reform, the Data Protection and Digital Information Bill going through Parliament, which we're referring to as the Data Reform Bill because that's what it's doing. It's possible that there will be some changes to UK data protection law, so it might be that this comes into play at some point. So the IDTA sounds great. There are a few cons to it though that I think are worth mentioning here. So I think the main health warning with it is that it only serves for transfers outside of the UK. So if there's multi-territorial data sharing going on involving the EEA, then you can't rely on the IDTA alone, which I think points to organisations that have global data flows, whether these are in-group or external, probably more likely to go for the EU SCCs with the ICO addendum to deal with UK exports, just because that's going to be the neater way of doing it. Additionally, the IDTA doesn't contain the mandatory data processing requirements under Article 28 of the UK GDPR, whereas the new EU SCCs have actually incorporated the Article 28 requirements in Module 2, I think it is, control of the processor. So you've already got that in there. So the IDTA doesn't, you'll need to have a separate data processing agreement, which does mean that you have additional linked agreements, but that sort of goes into the fabric of that document anyway, because you've got your commercial linked agreements too. So you may see that as either a pro or a con. I think the main difficulty being it does complicate the patchwork ever so slightly of your data transfer agreements. The IDTA also doesn't gold plate the requirements. So what do we mean by that? The EU SCCs, as I think we normally see with EU laws and the way that they are implemented, really do make it to the highest standard that it can be. A good example here is to challenge a government request for information under the EU SCCs. You can challenge it if there are reasonable grounds to consider the request as unlawful. Under just the IDTA alone, you only need to challenge it if there are significant grounds to think the request is unlawful. So you can see there how the EU SCCs have gone a bit further. Please may I have the next slide? Okay, so the second option for you here is the EU SCCs, the new ones, plus the addendum. So advantages here, I think we're all familiar with the old EU SCC, so it is a more familiar format there. Human nature, we like what we know, and IDTA does look different. It doesn't have that modular format and things like that. So familiarity an advantage here. Additionally, they really require very little negotiation because most of the provisions are actually standard and can be integrated within your commercial and intergroup agreements. So this can allow for a more quick and easy contract negotiation between the parties. So if you've no time for long and protracted negotiations, then that might be better to use these. Also a little bit more flexibility here as well. They can be a low cost solution compared with binding corporate rules, which Vicki mentioned earlier. But you do here have the need to conduct and crucially maintain transfer risk assessments, which has a resource and cost implication for organisations. So I mentioned earlier about the transfer risk assessment being something that you need to consider throughout the life cycle of your data transferring relationship. It's something that you'll need to go back to and check that your mitigations and your safeguards are still appropriate and that nothing has changed that would mean that you might need to incorporate additional safeguards to ensure that there's no erosion of the protection of personal data. So this might have a resource and cost implication, so weighing that up. As I said, like with the IDTA, if the ICO need to make changes to the addendum, such as to correct errors, and the parties can end the addendum if the changes have an effect on costs and risks which can't be mitigated. I think the biggest advantage of this particular setup for international organisations is it covers both UK and EU transfers, so it's all neatly wrapped up in one rather than having to have several documents. It also includes the Article 28 wording, data processing wording, if that's applicable to you. But one health warning here is you need to make sure you include your subject matter and duration of processing, because these things are missing and it's your responsibility to make sure that they go in there. So as I said earlier, inputting of the practicals, which is really where you have most of your drafting work required for these documents, is really important to make sure that they reflect exactly what you're doing in practice. So I think I said I would run through the cons here as well. The addendum only works as an addendum to the new EU SCC. So I think last year when the ICA was carrying out its consultation, it considered whether to draft the addendum so it could apply to data transfer agreements with other countries, so perhaps like New Zealand or places like that. Ultimately, that didn't happen, and now what we have is a document that only works with the EU SCCs. So at present, you aren't able to use it for other things. And so if you work with other countries and you've got data transfer agreements for your multinationals, you can't use this, it could cause some issues. There's also limited scope for amending the standard contractual clauses without rendering them invalid. So it does sort of limit their flexibility slightly there. I think you have a little bit more with the international data transfer agreement. The core legal clauses need to remain the same. And the amendments are just to ensure that the documents reflect the relationship in practice. I think ultimately, when you're going to want to reach for EU standard contractual clauses and addendum is if you're envisaging more wide-ranging transfers to other places such as Australia, which Vicki's mentioned as a good example here. So that's when that would really be more applicable. But if you've got a more straightforward UK to EU transfer, then the UK IDTA is probably going to be your better bet there. So really it just depends on the realities there. And the other thing to think about is, are you actually transferring personal data? I think we're looking to amend the definition of anonymizing personal data as well. So if your personal data is truly anonymized and it's not a restricted transfer, that can just make things a little bit easier because you don't need to consider this. So do you need to transfer it as personal data? I think would be a practical point here. I think I'll hand over to Vicki now just to take you through what's next and what we've got coming up, the Data Protection and Digital Information Bill, as I mentioned earlier.
Thanks, Bronwen. Just sort my screen out. So Bronwen mentioned that there's the Data Protection and Digital Information Bill. And this is the UK government's apparently radical change to data protection law, although whether or not it is radical, I think depends on your views on what might be radical. It does make some changes, and Bronwen mentioned the definition of personal data has changed. The wording used is different in the bill. But the ICO has said, or when I've heard them speak, they have said that it doesn't actually change the definition, it's just different wording. But I'm not entirely sure that's true. And of course, our job as lawyers is to pore over these finer details and these slight tweaks in languages and decide if is it actually a change. And I think a lot of the lawyers that I've spoken to think that it is a change. And small tweaks like this could potentially mean that our adequacy decision is at risk. So at the moment, the UK says that all of the countries in the EEA provide adequate protection, and the EU has made a decision that the UK provides adequate protection, so that an entity that's based in an EU country that is transferring information to the UK doesn't need to put in place an additional safeguard. But there is the potential that if we change the law in too significant a way, it puts our adequacy decision at risk. And I'll explain the photograph in a minute, but this is basically my face whenever I think about this, because I went to a talk recently with where the ICO was speaking about the future of data protection law, and there were various people representing different industry bodies all talking about the new bill. And the question of adequacy came up. And the key question is, are we going to keep it? And somebody on the panel who worked for BT is friends with the person in Brussels who is responsible for dealing with adequacy and looking at these things. So he had messaged his friend and asked him, and his friend had said, it's at risk, you need to be prepared, was the essential sort of message. Interestingly, somebody from a, I can't remember where this lady was from, anyway, somebody else who was speaking on the panel that was representing digital innovation, I think, but working with digital companies. She had heard this same individual from the EU speak, and he'd said there that it was all fine, and that they didn't think that the digital information, the Data Protection and Digital Information Bill would amend UK law enough to put adequacy at risk. So two completely conflicting perspectives apparently coming from the same person, which is really helpful or otherwise. So in terms of whether our adequacy is at risk, the short answer is that we just don't know, unfortunately, and we just have to wait and see. And my personal view is that the implications of this are so huge for trade that the UK government will do something about it. Or I don't know if that's my view or my hope. My hope is that the UK government will do something about it to ensure that we do keep adequacy, but it is a risk. But it's something that we just won't know until the bill is passed in its final form and the EU scrutinises that. And at the moment, it's still going through its process in Parliament and being debated, and all the different tweaks and changes around the edges are being made sort of almost as we speak today. So we won't know until it's settled and in its final form. And then when the EU have had a chance to look at it, nothing moves very quickly in the EU. So who knows when we'll know the outcome, but it is something that that we do need to just be aware of in case, as Bronwen said, you may need to make tweaks to IDTAs, etc. in the future. Just before we finish, for those of you that haven't seen me speak before, this is a picture of my daughter. I like to throw it in because data protection is quite a dry subject and it's a funny picture. But as I said, it does quite adequately represent my face when I think about adequacy and the disaster it will be if we lose it. We were at Disney World, we were on a dinosaur ride. I love dinosaurs. You can see from her face, she is not keen. And I love this photo because it just, you can see exactly what she's thinking based on her facial expressions there. Right, moving swiftly on. Just before I hand over to Paul to finish up, we do have a data protection e-learning available to anyone who would like to sign up, and essentially it's an e-learning course that you can roll out to staff that covers an introduction to data protection. It does talk about sharing personal data, but also how to deal with subject access requests and rights of individuals. It's a practical course that's aimed at staff or other people that you work with just understanding the basics of their own responsibilities. It's from £3 per user, as you can see on the slide. If you would be interested in hearing more about it, I think Alice is going to launch a poll for us. So if you would be interested, just click yes. If you're not interested, please, it's absolutely fine to say no or to not respond, and I'll just give people a moment to to answer that. Should have launched the poll and then told you the story about my daughter, really, shouldn't I?
Well, I can fill this while we're waiting for the results,
okay,
Vicky.
Thanks very much.
Did your daughter consent, or is she below the age of consent? Is that consent to use the picture of that coming from you as the parent?
No, because she's now 13, so she has to give me consent to use it, but I've spoken to her about it, and although outwardly she says, oh, it's a horrible photo, she's secretly quite chuffed, I think, that it goes on tour with me and gets seen by lots of people. So she's
in
very
return for
just she feels famous. That's her.
Okay, I think we're probably done on the poll, aren't we? I think most people seem to have voted. Thank you. And thank you, Vicky and Bronwen. We do have some questions. The first one is a really easy one. Will you send us these slides? Yes, they will be coming in the next few days, along with the recording, so that we will be sending them out, and they will also be on the EMIG members website as well. There's a question, and I think this will be to Bronwen. When is the IDTA effective from?
It's now. It's live. We're using it. So if you felt after my weighing up of pros and cons that one looked better, then do go for it. There's lots of helpful guidance on the ICO website as well. If you're not familiar with the document, as I said, SCC is more familiar format. IDTA is something new, but something new is not necessarily a bad thing.
Thank you, Bronwen. Keep the questions coming in, by the way, to the Q&A, not in the chat box, into the Q&A box. Is it correct, and I think you did cover this actually, Bronwen, is it correct that the substantive clauses of the IDTA are not for negotiation and can only be amended to enable the agreement to make sense? And sorry, I should just say, when I said you did cover this, the question came in before you covered it.
I saw it and I thought, fantastic, I'm going to cover this. So
yeah.
Hopefully that's answered it for you. Yes, you're right. That's the correct interpretation there. It's really more practical and like to make sense, or if the ICO then implements something as a result of changes to UK data protection law as well.
Okay, thank you, Bronwen. And one more, what's the advantage of the IDTA if the SCCs and the addendum will work and cover transfers from the EU to and have the Article 28 clauses in them? So is there an advantage in using the IDTA?
I think because you can incorporate your linked commercial agreements, I see that as being quite a big advantage there. Also, the fact that it doesn't gold plate the requirements as well, and I think some people find it simpler to use. On top of that, you've got more scope for different scenarios that weren't envisaged by the EU SCCs in the addendum, because they're limited to the 4 modules set out there, and it's all very basic: controller to controller, controller to processor. There's a bit more scope for your more unusual relationships envisaged by if a process is passing on to another controller-owned organisation, if that makes sense.
That's very helpful, Bronwen. Actually, I sometimes speak to people who've, the businesses between the UK and the EU are quite interchangeable. If data, sorry, it's a question from me, if the data is being exported from the UK to the EU, presumably we just rely on adequacy. Exactly. So there's no need for any IDTA with data going to the EU. And if data is coming from the EU via the UK and going somewhere else, then presumably you are going to need both forms, or just the standard contractual clauses plus the addendum. That would probably make sense if data is coming from the EU as well, and that there will be some standard contractual clauses, or they would probably envisage that they would want to have some standard contractual clauses if the data is originating in the EU. Is that the case?
It depends how long it will be here for. I think Vicky mentioned it's the is it a transfer? It's based on how long it will be there here for, if that makes sense. So whether we're involved or not, or whether it would be an EU directly to that country, because is it a transfer from us to the next country?